Good day, students. In today's class, we will be looking into Management and Administration, Unit 4 and Company Law. So here in this unit, we will be looking about directors, their legal position, classification, their powers, duties, appointment, qualification and disqualification. We will look into the topic one after the other. So first, who is a director? According to Section 2 of 34 Companies Act, it defines a director means a director appointed to the board of the company. Next, let us look into the legal position of directors. A director may act as an agent, as a trustee, as a managing partner. He is an organ of the company, as an employee, as an officer. So he plays various roles in the company. When you consider agent, as there is a relationship between the principal and agent, or the agent acting on behalf of the principal, here the principal is the company. So the director acts on behalf of the company. He signs contracts, he enters into contract. So it is that he acts on behalf of the company. Next one, he acts as a trustee. So he is a person who manages the affairs of the company. He manages the securities. He manages the assets of the company. He acts as a trustee for the assets of the company. Next, if you see a director act as a managing partner. So he is a managing partner by which he manages the entire affairs of the company. He is also an organ of the company. So as a human, if you consider a human, brain is an important organ of human, where brain directs every other organ to do its work. Similarly, for a company, director plays a very vital role in directing everyone to do their respective task. He is as well in full-time employment, so he's an employee of the company and as well an officer in charge of officer in default in the company. So these are the legal positions of directors. Next, we will move on to what is the minimum requirement to be a director. So it is that in case if it is a public company, then the minimum of 3 directors can be appointed. In case if it is a private company, then a minimum of 2 directors can be appointed. In case if it is a one-person company, there would be a minimum of 1 director in the company, and it is that the company can appoint up to a maximum of 15 directors. Okay, it can appoint up to 15 directors, and it should have a resident director, where it means that the previous year the director should have stayed in the country for about 182 days. So a company has to mandatorily have resident director, then women director. So every company whose paid up share capital is greater than 100 crores and turnover above 300 crores, it's mandatory to have a women director in the company. Next, moving on to the classification of directors. Here you can see 3 major classifications of director. So first one, it is based on categories. Secondly, it is based on appointment, and thirdly, it is based on listing agreement. So first one, based on categories: managing director and a whole-time director. So managing director, as the name says, the person is a managing director of the company who manages the entire affairs of the company. So he acts as a managing director, and his period would be 5 years, and it could be extended for another 2 years as well. Okay, next is whole-time director. Whole-time director who is in employment, full-time employment in the organization, so he is termed as a whole-time director. Next, moving on to the next classification, which is based on appointment. The first one, first director. So who is a first director? First director usually would be the promoter of the company. Okay, first director would be the promoter of the company, and this person would be appointed either during incorporation or after registration of company. This person would be appointed. Okay, next is residential director. As we have seen already, it is that a residential director is a director who has stayed in the country for about 182 days in the previous year. So then we call the person to be a resident director. Then casual director, it is that when there happens any vacancy, okay, when there arises any vacancy. So when will the vacancy arise? Maybe it would be due to resignation of a director, or it might be the director was disqualified because he was insolvent, he was disqualified, or because of a sudden death of director. So when vacancy arises, then a director would be appointed to fill this casual vacancy. Okay, so then he is called as a casual director. Next, additional director. So in case of the company's articles of association is permitting to appoint director, then not exceeding the maximum limit of 15 directors, director could be appointed, called additional director. Next, it is alternate director. So when is this alternate director appointed? When the original director who is acting at present, in case of that director is absent for a period of 3 months or more, then a director is appointed in his place and the person is called as alternate director. Yes. Next you have sixth one, small shareholder director. A company having 1,000 plus shareholders, the shareholders appoint or the shareholders select a director for themselves, and that director is called as small shareholder director. Next you have shadow director and de facto director. So both these directors, either shadow or de facto director, they are not appointed officially. Okay, they are not appointed officially, but it is that the shadow director has power to manage the affairs of the company. He gives professional advice, and that is how it is. He is called as a shadow director. And this de facto director, if you see, the outside world knows that this person is a director, but then he is a person who is not officially appointed, de facto. Next you have rotational director. It is mandatory that in a company 2/3 of the board members has to be in rotation. Okay, and they'll have to be reappointed after every annual general meeting. Next is the women director. As we have seen already, every company, it is mandatory to have a women director, and the criteria is the paid up share capital should be greater than 100 crore, and as well their turnover should be greater than 300 crore. Then it is mandatory to have a women director in the company. Nominee director. So who is this nominee director? Nominee director is a person who is appointed by a third party. This third party can be debenture holder, or it could be a banker or a financial institution. So debenture holder and banker together, in order to safeguard their interest, they appoint a director for them, who's called as a nominee director, in order to protect or safeguard their interest. Okay, because they have advanced loan to the company, to safeguard their interest, they appoint a director, then he is called as a nominee director. Next you have director by central government. So when is a director appointed by central government? When 1/10 of when people that is when members of the company, when they have 1/10 of voting power, and in case if they find that something is not going good in the company and they wanted a director to be appointed by central government, then they petition the central government for appointment of a director. Then central government would appoint a director to safeguard their interest, so which is called as director by central government. So the major criteria here is the members having 1/10 of voting power of the company, they would request central government for appointment of director. Then the third major classification here is based on listing agreement. So based on listing agreement, it is directors are classified into executive director, non-executive director, and independent director. Executive director is a person that is managing director as well as whole-time director. Both are called as an executive director. When it is non-executive director, they don't look into the affairs of the company. On day-to-day basis, they don't look into. Independent director, they don't have any material benefits from the company, they just act as watchdog in the company. So this is about the classification of director. Next, moving on to the appointment procedures of director. As we have seen in classification, maybe for an alternate directors, in case if the person is absent for 3 months, then an alternate director is appointed. In case of nominee director, to protect interest of people who have advanced loan, a person is appointed by the third party, is called as a nominee director. So on various situations, people are being appointed as directors, as we have seen in classification. Maybe just you can go through this. And a director is appointed by company in general meeting director is appointed, and normally this director's name would be in the articles, or as members or subscriber in MOA, Memorandum of Association. And this person who is appointed as a director, he has to give his consent to be a director, where he has to file form DIR2 before appointment, and the company also has to file a form DIR12 giving particulars of appointment along with DIR2, which the director has submitted within 30 days to the registrar. Next, moving on to resignation and removal of directors. So it is that in case if a director wants to resign, then he has to give it in writing. The board must take note of that, and they will have to inform the registrar within 30 days of receiving this resignation letter. And as well as the resigning director also, he must forward a copy of resignation along with reason to the registrar in form DIR 11 within 30 days. So the board must also inform the registrar, as well as the resigning director also must inform the registrar. And when will the director be removed? So it is that the director would be removed after his period is over, after his term is over, that is after 5 years, he will be removed from his position. Next, disqualification. When would the director be disqualified? So director would be disqualified in case if he is a convicted person, if he is convicted, or in case if he is found guilty of any offense, or he is disqualified by court for certain period of time, or he has not paid any calls on shares previous 6 months, in case if he has not paid, in case if he has not obtained a director identification number, in case if he is of unsound mind, in case if he is declared insolvent. So on all these grounds, director is considered to be disqualified. And ineligibility, if you see a director, in case if he has not filed financial statements, annual returns for continuous 3 years, then he becomes ineligible. As well, every director disqualified should inform the company in form DIR 8 before appointment or reappointment. He has to inform the company. That is very important. In case if he is not informing, he would be disqualified. Then other thing is, in case if the director is making himself absent for all the board meetings for 12 months at a stretch, in case if he is absent for all the board meetings, then also he is considered to be disqualified. Then what is director identification number? So director identification number is a unique number which is given to directors, and it is an 8-digit number given by central government. So what is the procedure for getting this DIN? The particular individual will apply to central government, where the applicant will file DIR3 and as well as DIR4, which would require the proof of the person, residential address, proof of identity, photograph, digital signature, everything together has to be filed in DIR4, and it has to be submitted. Central government, after verifying all the documents, in case if they find genuine, then they will grant this DIN in a month's time. In a month's time he will be getting. And as well, the company has to inform the director that he has received DIN, and only after this DIN is received, he is eligible to be a director of the company. Okay. Then directorship. When we talk about directorship, a person can hold maximum of up to 20 companies. He can hold up to 20 companies simultaneously. He can hold up to 20 companies, and in case of public company, then it is limited only to 10. Then what are the powers of directors? If you see powers of director, they have rights. They have power to make calls on shareholders, to authorize buyback of securities, to issue securities, then to borrow money, to invest funds of the company, to grant loans, to approve financial statements, to appoint or remove key managerial personnel, to appoint internal auditors or secretarial auditors, to enter into contracts with related parties. These are certain powers which director vests. As well as there are certain restrictions on power because it requires special resolution. So what are those? in case if the director wants to sell or lease the company's undertaking, then he has to wait for a special resolution being passed in the meeting. To borrow money exceeding the paid up share capital, he has to get approval in the meeting. So these are certain areas where restrictions are imposed on his powers. And other powers, if you look at, he can make charitable contributions that is, in case if it is exceeding 5% of an average net profit, then he has to seek the approval of the board. Then he has rights or power to form committees. So what committees he would form is, he has right to form audit committee, nomination and remuneration committee, stakeholder relationship committee. He forms all these three committees and he has power to form these committees. Then he is also having power to make political contribution up to 7.5 percentage. That is, in case if it is exceeding up 7.5 percentage, then he has to get approval from the board. A resolution has to be passed, and after that only he can exercise his power. Then moving on to the duties of directors. So a director has to act in good faith to promote the objective of the company. He has to act in accordance with the articles of the company. He has to refrain himself from situation that is contradictory, that is creating conflicts, rivalry, and it is against the interest of company. Then he has to refrain himself. Then he should not try to achieve undue gain or advantage for him or for his relatives or for his partners. He should not get undue gain. And in case if he is found guilty, then he must pay back to the company. uh, Disclosure of interest, every director must disclose nature of his interest towards the company. And in case if he is acting contradictory to the provisions of company law, then he would be punishable with fine of not less than 1 lakh, but which may extend up to 5 lakhs. So these are certain duties of director. Yes, we have come to the end of the slide. So I suppose uh, in this 15 minutes of time, it would be clear about director, who is a director, legal position of director. We have seen about the classification of directors in detail. Then we saw about the appointment of director. We also saw about director identification number, what is the procedure to apply. As well, we saw about qualification of director, removal and resignation of director, and finally we completed seeing powers and duties of director. Thank you. We would be meeting very soon in next video. Thank you.